Happy New Year to everyone. I think you saw on our first page, we updated our graphic. It is now business in 2023. We're glad that you're able to join us this afternoon. We have a couple of statutory updates for you and then some presentations regarding employment litigation, which we think will be helpful. So with that, let's start off as we do every webinar with some COVID information. The numbers are pretty stagnant, as we've seen for the past several months. We're not seeing a significant spike in cases. It's more that flat line that we've been experiencing. A little bit of an uptick in cases at the beginning of December, which has remained fairly consistent, but nothing alarming from a public health standpoint. Next slide, please. Again, we're seeing the light yellow and light orange colors that we like to see, not too much dark. New York City and the southern part of the state have a little higher incidence of new cases than the rest of the state, but in general, the numbers have been pretty good. In fact, in New York City, I think you can see there has been a 20% decrease over the past 14 days in new cases. Along with these case numbers, we are not seeing any new regulations requiring masking or any other mandates. New York City still has a recommendation in place, but other than that, there's nothing that's being required. So good news on the COVID front, which we're now almost 3 years into. So let's move on to our first presentation of the day, which is from me. And I'm going to talk to you about an amendment to Section 201 of the labor law. So prior to this amendment, which was signed into law by the governor late last month, Section 201 of the labor law required the Commissioner of Labor to provide employers with copies of workplace posters that had to be posted by the employer in a conspicuous place. Most employers are very familiar with this rule. You have your required federal and state posters all put up typically in a break room or some other area where they are readily visible for your employees. At the end of December or middle of December of last year, Governor Hochul signed into law an amendment to Section 201, next slide please, which did a couple of things. Number one, the amendment states that digital versions of these posters must now be made available through the employer's website or email. Many of you may do this already, but it's now been codified into law. The amendment also states that employers must provide notice that documents required for physical posting are also available electronically. Importantly, the amendment also says that all other documents required to be physically posted at a work site pursuant to either state or federal law must also be made available electronically. So the amendment to Section 201 also deals with electronic availability of federal postings as well. The amendment is effective immediately. So next slide. That leads us into potential action items for employers. Number one, make sure that you have current versions of all federal and state mandated posters that are physically posted. This is something that you should do on a regular basis. These posters change from time to time. We let you know about changes when we are aware of them, but it's always a good idea, at least right now, certainly, go through, make sure your posters are updated, make sure that they provide the information that they need to be provided. Also, make sure that these posters are available digitally. This is what the amendment is requiring you to do. You can either get the posters from state or federal websites or a poster vendor if that's something that you use in your workplace. In addition, you have to provide notice that these documents are available electronically and how employees can obtain them, either through email or website. So that is the amendment to Section 201 of the labor law. For our next legislative update, we have Sanjeev D'Souza on. Sanjeev is our deputy chair of the Labor and Employment Department here at Bond, and he has been following this closely. So Sanjeev, welcome, and thanks for being on.
Thanks, Adam, and thanks everyone for joining us today, and Happy New Year. So as Adam mentioned, I'm going to give a brief update on an amendment to Labor Law Section 167. That's a New York statutory provision that's been in effect for over a decade now, and it restricts healthcare employers from requiring nurses to work more than their regularly scheduled hours, except under very limited circumstances. And the statute has historically included 4 exceptions that would allow a healthcare employer to require an employee, a nurse, to work more than the regularly scheduled hours. One such exception is where there is a healthcare disaster that increases the need for healthcare personnel. A second exception is where the employer is operating in a county where a federal, state, or county declaration of emergency is in effect. So, for example, during COVID, for many healthcare employers covered by the statute, they were operating during the state of emergency declared by the governor or by the federal government that gave them a greater leeway to be able to mandate overtime. A third exception is where the healthcare employer determines there's an emergency necessary to provide safe patient care, where that emergency was unforeseen and really could not be prudently planned for. And it's a relatively narrow exception. The fourth being an ongoing medical or surgical procedure in which the particular nurse was actively involved and who needed to be present through the completion of the procedure to ensure the health and safety of the patient. So these are the 4 limited exceptions under 167. Healthcare employers are defined by the statute as employers that are operating pursuant to Article 28 of the Public Health Law, and that includes hospitals, nursing homes, diagnostic treatment centers, including those that are operated by the state or a public corporation or a political subdivision. It also applies to facilities that are operated by the state, political subdivision, or a public corp that are operated or licensed pursuant to the mental hygiene law, the education law, the correction law, or Section 500 of the executive law. And nurses were defined by the statute as registered nurses or licensed practical nurses. So this was a statute that's been, like I said, been in effect for several years now. It did not previously include any specific penalties or authorize the state to impose penalties on employers for violations, and it was limited to these defined healthcare employers. So over the last year and a half, several bills were introduced in the state's assembly and the Senate to amend 167 and expand both the reach of the statute and then create penalties. So one such bill would have expanded the statute to home healthcare agencies, and then 2 other bills would have expanded or created penalties for violations. So where for a first offense, an employer could be fined a certain amount of money, and then it increased based on subsequent violations. And additionally, these bills provided or proposed that the nurse who was required to work the overtime would receive a certain additional payment from the employer. So all of these bills were introduced. They passed the Assembly and the Senate, and they went to Governor Hochul's desk in approximately mid-October of 2022. She considered them over the last several weeks and months, and on December 30th, she signed one of those bills into law. She vetoed the other 2. So the bill that she enacted is one that now calls for a penalty for an employer who is found to have violated the law of $1,000 for the first violation, going up to $2,000 for the second, and then $3,000 for each third or subsequent violations found by the Department of Health. Additionally, this amendment provides for a penalty, actually a payment that the employer would have to provide to the nurse who was required to work the overtime. So they would get 15% of the overtime payment on top of that payment for the overtime hours they were required to work. Governor Hochul vetoed the other 2 bill. So that the one that would have expanded the statute to home healthcare agencies, as well as a separate statute that would have imposed a greater financial penalties on employers for violations. She also rejected a proposal to limit the amount of time that an employer could rely on the state of emergency exception to the statute. Under the proposal, it would have limited the period of time to 30 days or less, whereas during COVID, employers were able to rely on the stated declaration of emergency for an extended period of time because there was such an increase in hospitalizations and cases and the need for staffing. So, this is a fairly significant development for employers that are covered by 167, so hospitals and nursing homes in particular. It makes it all the more challenging because these employers continue to deal with an ongoing staffing shortage. So it was certainly something that was strongly opposed by employers and association groups. And the argument being, while this is well-intentioned, the rationale is just not supported by existing conditions. So by imposing a penalty, the rationale being that the penalty would dissuade employers from mandating overtime, doesn't really play out when you're dealing with a healthcare shortage and an ongoing health crisis, which although COVID numbers are declining, we continue to deal with a significant number of hospitalizations that are related to COVID. So the upshot of all of this is that now employers covered by the statute do face these monetary penalties and having to provide this additional payment to nurses who are required to work overtime in violation of the statute. There will certainly be more developments on this amendment in the weeks and months to come, and we will provide those as they arise. Last comment is that the statute takes effect 60 days after the governor's signature. She signed on December 30th, so it looks like February 28th of 2023 will be the start date for the amended provision. So thanks very much, everybody. Happy to take further questions down the road.
Sanjeev, we've seen a number of amendments like this go into effect in the last couple of years, followed up by guidance. Is this something where you anticipate potential guidance that might help employers with implementing these rules?
Adam, I would certainly hope that there will be some guidance and more specifically, some updates to the regulations that currently exist for 167. There are certainly going to be questions as to the investigations and how they would be conducted by the department, and under what circumstances the penalties or the fines may be imposed. And there will continue to be questions about the impact of the statute on employers that are unionized and have collective bargaining agreements that provide for mandatory overtime and how the statute plays alongside those agreements. So more to come.
Thank you, Sanjeev. And for those of you who are on who would be an impacted employer, please reach out to Sanjeev with any questions that you might have. Okay, next up, we are going to move on to a topic that is near and dear to my heart, which is employment litigation. We had on Subha Viswanathan a couple of weeks ago, who's going to be providing a series on wage and hour law issues. Employment litigation issues are equally as important. So we figured that it would be helpful to provide a similar series on those types of issues. So what I'm going to do today is a very basic outline of what types of employment litigation claims can be made and what is the process for adjudicating those claims. Most employers are familiar with maybe one of these processes, but I'm going to walk through all of them so that we get a context for the upcoming series on employment litigation. So next slide, please. All right, so first of all, what laws prohibit employment discrimination and or retaliation? There are both federal, state, and local laws dealing with these issues. So on the federal side, We start off with Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, gender, pregnancy, sexual orientation, and national orientation. Similarly, there's a federal law called the Americans with Disabilities Act that I'm sure many of you are acquainted with, and the Age Discrimination in Employment Act. Those statutes prohibit discrimination on the basis of disability and or age. So on the federal side, there are these very specific statutes that address very specific types of discrimination. Next slide, please. The state, our New York State, also has a similar law which prohibits discrimination, and that is the New York State Human Rights Law. I've listed out the bases on which you could bring a claim for discrimination under the New York State Human Rights Law there. As you can see, it is more broad and more encompassing than the federal statutes listed on the previous slide. Similarly, New York City has its own anti-discrimination statute, which prohibits discrimination on the basis of the protected characteristics identified in the slide. Again, New York City's law or statute is more broad than the federal statutes. Each of these statutes identified, the federal, the state, and the local, also contain anti-retaliation provisions, which prohibit employers from retaliating against employees who raise protected concerns about discrimination. So, for example, if you have an employee who raises a concern to human resources that he or she is being discriminated on the basis of race, and you then take an employment action against that person because they brought a claim, that would be considered retaliation, and that would be prohibited by all of the statutes mentioned. So in the context of an employment discrimination or retaliation claim, you start off with what are the statute or statutes that are implicated. In addition to the federal and state statutes listed here, there are other federal laws that prohibit against discrimination, such as 42 USC section 1981, which prohibits discrimination on the basis of race. So a complainant or an employee who is concerned that he or she is being discriminated against on the basis of one or more characteristics would have to be protected under one of these statutes. Next slide, please. So next, what is the process that an employee would follow? There are two different avenues. Well, I shouldn't say two. There are a number of different avenues that an employee could take. So first, let's talk about the administrative process that an employee could take. So an employee believes that they are being discriminated against. We'll keep race as the protected characteristic in my analogy. What can they do? So one option is to file a complaint with the New York State Division of Human Rights. That is New York State's administrative agency that is tasked with enforcing the New York State Human Rights Law. Similarly, an employee could file a complaint with the New York City Commission on Human Rights. That is the administrative agency that's tasked with enforcing New York City's human rights law. An employee could also file a complaint with the Equal Employment Opportunity Commission, which is the federal government agency that is tasked with enforcing federal anti-discrimination statutes. In addition to pursuing an administrative remedy via one of those three administrative agencies, a complainant or an employee could also file claims in state or federal court. Now, I should add the disclaimer that there are certain federal claims that require the employee to exhaust their administrative remedies before filing a lawsuit. So, for example, Title VII requires employees to first go to the EEOC before they file a federal complaint in federal court. Other federal statutes don't have the same requirement. So, for example, Section 1981 does not have that requirement. New York State claims, based upon the State Division of New York State Human Rights Law or the City Human Rights Law, don't have any exhaustion requirement. So employees, if they wanted to, could go right to court and file a claim in New York State Court. Next slide, please. So what is the process under each of those different avenues that an employee could take? Under the New York State Division of Human Rights, An employee would file a complaint. You, as the employer, would be offered an opportunity to submit a position statement in response to the complaint, and the complainant would be offered the opportunity to submit a rebuttal. The New York State Division of Human Rights would then have an investigator who would conduct an investigation into the allegations in the complaint. That investigation can include specific requests for documents from you, from the complainant, from the employee, and witness interviews. These witness interviews of late have taken the form of phone calls. They used to be in person, but I haven't seen any in-person interviews in the last 2 years or so. Investigators are more and more frequently utilizing phone conferences to substitute for these fact-finding in-person interviews. After the initial investigation is done by a regional office, there will be an initial determination. This initial determination will either find that there is probable cause or no probable cause to support an inference of discrimination. If there is a no probable cause determination, that will be the end of the New York State Division of Human Rights process, pending an appeal by the complainant, which is rare. If there is a probable cause determination, then the case will be referred for a mandatory pre-hearing settlement conference, where you as the employer will be brought together with an administrative law judge and the complainant, and you will attempt to reach a resolution. If you're not able to do that, it will go to a public hearing. I have the word trial on the slide. The state likes to call it a public hearing. They're essentially the same thing. After the public hearing, there will be an initial determination by the administrative law judge that presides over the hearing, and ultimately a final order by the Commissioner of Labor. Now, here's what's important in the New York State division process. It has teeth. New York State, through this process, the Commissioner of Labor can issue an order requiring you to either reinstate the employee if you terminated him or her, to train your staff, but it could also require you to pay monetary damages, such as back pay, compensatory damages for mental anguish, attorney's fees, civil fines, and potential penalties. So this process is a very important process. I know many of you have gone through it, but I wanted to provide a general overview of how it works. The New York City Commission on Human Rights process is essentially the same as the New York State Division of Human Rights process. Next slide, please. The EEOC process is a little different. Remember, this is the administrative agency that is tasked with enforcing the federal anti-discrimination statutes. So the EEOC process initially is very similar in that there's a complaint filed, there is a response from the employer and a potential rebuttal from the employee. There's a factual investigation that may include a request for documents and or interviews. However, the possible outcomes from the EEOC process are very different. So the EEOC can do one of a number of things. One, they can issue a dismissal and notice of rights. So if the EEOC investigation does not yield facts that would lead to a claim, then they will issue a dismissal. However, I should note, when the EEOC dismisses a claim in this manner, they issue a right to sue notice to the employee. So even though you've gone through this EEOC process and investigation, the employee at the conclusion of it will be presented with a notice of right to sue, meaning they can go to federal court and file a lawsuit against you. Another potential outcome is that the EEOC issues a probable cause finding, which will then trigger a couple of things. If they issue a probable cause finding, the parties will be invited to a conciliation process where a settlement is attempted. If the conciliation process is not successful, the EEOC then has the right to file a lawsuit in federal court on behalf of the complainant. However, this very rarely happens. What is more common is that the EEOC will decide not to pursue a claim on behalf of the complainant and issue the same right to sue notice that they would have received if the EEOC decided to dismiss the claim. So the outcome of the EEOC process is usually the same. An employee will get a right to sue notice, which gives them the ability to file a claim in federal court. Next slide, please. So we talked about the administrative process on the state side, the administrative process on the federal side. There is also the opportunity for an employee to file a claim in court. And these are lawsuits that are filed either in state or federal court. And I have way oversimplified the litigation process on this slide. But I typically like to break litigation into 3 stages in my mind. The first stage is the complaint stage. That is where a complaint is filed and the defendant responds to the complaint. That's the complaint stage. The second stage of any lawsuit is the discovery stage. That's where the parties exchange information, both in written form and through depositions. Once discovery is completed, there is the trial stage where you prepare for and go to a trial. Cases or lawsuits, I should say, can be resolved at any time through a settlement. They can also be resolved through motion practice. So either through a motion to dismiss or a motion for summary judgment at the conclusion of the discovery process. Litigation in any of these contexts can be very expensive and drawn out. And stay tuned for more on employment discrimination litigation. I wanted to start off the series by giving you an overview of the process. Okay, next up, we have Lou and Jeff on, our regular contributors, to talk about negligent hiring, supervision, and retention claims. So Lou and Jeff, welcome. Happy New Year.
Happy New Year to you, Adam. Thank you for a great presentation. And let me make a shameless plug. If there's more you want to learn about discrimination criteria, standards, defenses, burdens of proof, and everything else, the biggest single chapter that we wrote in the book, which is the book which Lou and I edited and our colleagues at Bond wrote, called New York Employment Law, The Essential Guide, will give you 90 pages and 71 questions and multiple sub-questions about how all of this works. And if you care to read it, you're going to find out that Adam just absolutely nailed it. Our topic today is negligent hiring and negligent supervision. And while discrimination litigation is probably the single biggest form of defense litigation we do, negligent hiring and negligent supervision comes reasonably close. Basically, in either of those cases, something bad happened in the workplace, which involves one of your employees and a coworker, a customer, a visitor, someone else with whom your employee comes in contact as part of his and her work, and now the victim of that conduct has decided to sue you for what happened. There is a big difference between negligent hiring and negligent supervision. When we think about negligent hiring, we are talking about a plaintiff who is claiming that there was something that you knew or should have known at the time an employee was hired, that had you known it or acted upon it as you should have, you wouldn't have hired this person and none of this would have happened. Negligent supervision is a little bit more complicated because it's not just what you knew or should have known, but also more significantly, what you did. I'm going to leave the negligent supervision part to Lou because it's more complex, but I want to start with negligent hiring because when Lou and I talked about this, I pointed out, you know, a lot of what you knew or should have known at the time you hired somebody is information which we have already told you you either shouldn't be asking for or have to be very careful about asking for. So this is kind of a classic catch-22. You can't get out of the Army unless you're crazy, but if you try to get out of the Army because you're crazy, you clearly aren't crazy. So I'm going to give you a hypothetical. Last week, you hired somebody to be the shift supervisor for the second shift at the widget factory. And on his third day of work, the copier repair person came in to fix the copier in his office. He told her that he didn't think that women were capable of fixing a copier and patted her on the head in a very condescending way. She slapped his hand away, and he then proceeded to beat her to a pulp. You are now being sued. And what you're being sued on is the following claim. You either knew or should have known that your employee belonged to an anti-feminist fringe group. You knew or should have known that he had previously been institutionalized on an involuntary basis for violent bipolar disorder. You knew or should have known that he had 2 convictions for workplace assault, and you knew or should have known that he was an alcohol and drug user. Well, oops, that sounds just awful. What of that could you really have found out in a scrupulous pre-employment process? The history of institutionalization, not so clear. That's a disability, and there are limitations on how far you can probe on a disability. And we generally caution employers about asking about gaps in employment history, because that will sometimes lead to the disclosure of information that you should not have. This guy's off-premises, out-of-work conduct, his club memberships, the fact that he drinks and uses marijuana. Well, New York Labor Law Section 201D says that you cannot take adverse action against an employee for conduct out of the workplace which is lawful. So you can't ask about drinking, marijuana use. What are your political affiliations? What clubs do you belong to? Are you a gun owner? If it's legal, they're entitled to do it. What about his previous assaults? Well, yes, you can ask about convictions, and we've covered this in other sessions. In most of New York State at this point, you cannot ask about convictions on an employment application. And we generally counsel clients that you should not ask about prior convictions until you have already decided to make and made what's called a conditional offer of employment. The conditional offer is, we'd like to offer you this job subject to some background checking. When you do find that there are prior assaults, there is an 8-point process which you must go through as prescribed by the corrections law in determining whether there is enough of a relationship between that prior conviction and the job the person is going to do to warrant a down check. Mental impairments, well, those are generally disabilities, and there are a lot of limitations on asking about that. So now that I've told you there are problems with finding out just about everything that the plaintiff here says you knew or should have known about your shift supervisor, what can you do? Well, you can and certainly should, if it is a sensitive position where there's not going to be very close supervision, go through the criminal background history check. It is worth doing. In fact, you may want to do a complete background history check. And there are 2 ways you can go about it. You can just plain do it yourself. That generally means doing an internet search. It's of somewhat limited utility. You may find this person on the internet, you may not. I could find Lou DiLorenzo at Bond, Schoeneck King very readily on the internet, but I checked this morning. There's a whole bunch of other Lou DiLorenzos out there who may have committed crimes of which our Lou DiLorenzo is presumptively innocent. So you have to be careful about getting information which you can't use. The other thing you can do is you can use an external background checking company, of which there are many, and many of them are quite reputable. If you do, though, you need to know that there are some requirements that go with it. Federal and New York State fair credit reporting laws require that you can't use an external company to do a background check without first getting a separate, by separate I mean as a separate document, signed authorization from the applicant to conduct the background check. And then also you have to give, under federal law, a copy of the corrections law criteria for dealing with past convictions and a summary of rights under the Federal Fair Credit Reporting Act. In addition, New York law requires that if you do have an outside company do a credit check, then you have to tell the employee whether or not, tell the applicant rather, whether or not a report was requested and whether or not a report was rendered. The other thing I want to leave you with is this. Don't forget about checking references. It's kind of easy not to do that. You can learn an awful lot from talking to other references. You may ask an applicant to provide references. You can ask them to provide personal references. You can ask them to provide prior employees. Sometimes you will learn a great deal. Sometimes you'll just get a rank, what we call a name, rank, and serial number reference, which is generally repeated in a robotic monotone. Mr. DiLorenzo was employed by our company for 3 months. His position was shift supervisor on the second shift. His final salary was $22,000 a year. If they repeat that every time you ask the question and won't answer the question whether or not you would rehire this employee, you may have learned something. But in fairness, there are also other employers who give name, rank, and serial number references for every prior employee, which is kind of unfair to the good employers. But by all means, check the references. The field opens considerably once we get into negligent supervision. This shift supervisor has now been on the job for 6 months and something ghastly happens and you're getting sued. Lou, the floor is yours. You're muted, Lou.
Thank you, Jeff. Very good summary, difficult topic. I'll make just a couple of comments about the hiring situation. What Jeff talked to you about in terms of the Credit Reporting Act kind of responsibilities and so on. If you're doing background checks, make sure you're dotting all your I's and crossing your T's. Some of those procedures, if violated, can lead to class actions along the employment litigation lines Adam was talking about. So you want to make sure you comply with that procedure. You might want to limit it to those jobs that you consider high risk. The highest risk ones are where people interact with third parties or members of the public, so you have no workers' comp protection from a co-employee. Customer service reps, the airlines, those kinds of things. You want to make sure those people that interact, especially without a lot of supervision, which we're going to talk about in a minute, those can be high risk. So you might want to do an audit of what jobs you got, because there is expense involved in doing these background checks, but make sure you're doing it. This negligence area is a little bit different than what Sanjeev and Adam and Jeff and I typically see ourselves doing. The negligence standard, as Jeff said, is what we know or should have known. So it's, I've been married about 50 years, almost 50 years next year. And my wife is an expert, absolute expert with 20/20 hindsight. The things I should have done, the things I should have seen, the things I should have known. I had all these red flags and I ignored them, and now we're in a mess, or I've made a mistake. So that's taught me very well the kinds of things employers should take in terms of steps to avoid potential liability where somebody's second guessing you afterwards. And believe me, as we all know, it's not that easy to come to a fork in the road and take the turn when you turn to your partner and say, which one should I take? You decide. And then, of course, 2 hours later, when we're taking the wrong turn, it was all my fault because I was driving the car. So we want to be careful, and we want to be able to prove what did we do. So Jeff has already talked to you about the person's already been hired. And now we're talking about red flags that come up while they're working. And one of those red flags that may not appear is supervision. And we may be accused of negligently supervising someone. Second shift, third shift, a remote area, not having a lot of contact. So you want to watch those areas where you have potential risk and there's not a lot of supervision. Can something happen because we're not observing this person? We're not riding around in the truck with them. We're not riding around in the car with them. We're not checking in with customers or clients to see how the person's doing. It gets worse if we've ignored some complaints from people about this person. We didn't do an adequate investigation into a complaint we got from a co-employee or a third party. Those are all things that go hand in hand with a claim of negligent supervision. Did we properly train the person to begin with? Then did we monitor them? Did we evaluate them? So on. And if there's risk, you don't want to be in a position where you haven't done those things, because the claim's going to be, as Jeff said, there would have been red flags if you'd been paying attention, but you weren't even paying attention, so you didn't even see the red flags. In addition to the supervision issue, there's claims of negligent retention, that there were red flags that came up during employment, and I negligently retained this person in the position. In other words, we had some grievances. We disciplined this person for conduct. And the first thing in a lawsuit that happens is they get the person's personnel file through discovery, and they see that we warned them 3 times about having altercations with co-employees, or harassment, sexual harassment, or an assault on a client or customer or some third party, a contractor, the person demonstrated some propensities towards violence or misconduct, and we gave them a written warning, we gave them a final warning, we gave them 3 final warnings, we gave them 3 last chance agreements. There's only one final warning. Next time somebody does it, they should be fired. I hate to have witnesses explaining why we gave 3 final warnings, and we kept allowing the person to continue in the position. This is another case I don't like, and I've advised clients with a union contract where they've been a little squeamish about being able to prove just cause. Person engages in some misconduct, assault, harassment, sexual harassment, some form of misconduct. Perhaps they got some length of service, 10 years or more, and the person looks at it and makes a good labor relations decision and says, look, I don't think we have just cause under this union contract to fire this person. If we go to arbitration, I think they're going to get their job back. They might even get it back with back pay. And by the time we get to arbitration, it'll be 6 months from now. A lot of those cases I look at and I say, I don't think you have any choice. I think we have to fire the person and we have to go to arbitration, because I don't want you on a witness stand, or worse yet, what I've unfortunately run into lately is some of our sisters and brothers in the HR field testifying as experts and second guessing my HR people by saying, well, this person shouldn't have been retained after that first assault. And now you cross-examine the person and say, well, if you go to arbitration, you got to prove just cause under the labor contract. What's your experience been with that? Well, I've won some cases and lost some cases, but I believe this case, in my opinion, would have been won if they'd gone to arbitration. So I don't want that testimony. I don't want somebody second guessing. Take it to arbitration, fire the person, impose a long-term suspension, let them grieve it. Let's go to arbitration. If the arbitrator puts them back to work, now we're on the witness stand saying, in a negligence case, we did everything we could. We fired the person, but an arbitrator put him back to work. I've had some of those cases that have been so bad and the decision was so bad from the arbitrator, I went to federal court to have the award vacated. I didn't think we were going to win because the grounds are so limited in appealing an arbitration decision, but I wanted a federal court judge, district court judge, to say, I'm confirming this award. You must reinstate the person under penalty of contempt of court by federal court, because arbitration awards are not self-enforcing. They're voluntary compliance. So I've done that. So now my client can testify in front of a jury. We not only fired him, I went to arbitration, I lost. Then I appealed to federal court. There's no place else to go. I have to take the person back. And maybe I tried to buy him out or something. But we knew this was a time bomb that was going to go off and there was going to be another victim. But there wasn't anything left we could do under the laws of this state and the country. So
let me add to that, sure, if I may, because you made a terrific point there. It is the not asking that gets you in trouble. Let's say we've got a delivery driver who is now accused of assaulting a customer while he was making a delivery. And the claim is, if you had gone out to your other customers and asked how this guy was doing, they would have told you that he had a hot temper and threatened people. It's that you didn't call them. If you had called customer X and customer X said, yeah, the guy's okay. And it later turns out that, in fact, your driver threatened customer X, but customer X didn't tell you that because he was a nice guy and didn't want to get your driver in trouble. You're okay on that. It's what you actually could have found out and did find out. So dotting the I's and crossing the T's is important. It's also good management practice. So it's really not a high hurdle for you to jump.
No question. And your comment about reference checks being important, they're very important. They don't yield a lot of information these days, but you want to be able to say, I made the effort. I tried to find out from prior employers. I didn't know he had those problems at that other place of work. He lied on his application. And when I asked them for comments, they only told me name, rank, and serial number. So there's no other way. I don't have subpoena power to get his record at the prior employer. So you want to be able to do those things to say, look, I did what I could, and I didn't act negligently. I acted properly. In the supervision cases, there's often insurance coverage because it's a negligence claim. So even if you don't have employment practices liability insurance in a discrimination case or employment case, generally, this is a negligence case. So make sure that you get accused of any form of negligence, that you let your insurance company know. Provide notice under the policy, and you may get coverage for all the claims because they're all intertwined and interrelated. You know, when I think about this area of the law, I think about when I studied in law school, dog bite cases, right? New York is what we call a one free dog bite state. So if you can walk into court and say, look, geez, my dog, you get sued because your dog bites somebody. You want to be able to go into court and say, look, I didn't know the dog had any dangerous propensities. I didn't know it was going to bite anybody. Sorry, but the dog is a living being that made the decision to bite you, and I don't have responsibility for that. Some states, absolute liability. New York's not one of them. But if I had any indication, or if there's a second dog bite, I'm now on notice, right? And that's very similar in these cases. I'm now on notice that the dog has the potential to hurt someone. And now the law is going to hold me responsible for the second bite. And so with employees, oftentimes the only way we can be sure that a dog's not going to bite anybody is, you know, we put the dog down. In the employment context, we think about terminating the employment relationship, because that's the only way you can be 100% sure. You know, if it's a sexual harassment case, we can send them to, you know, one of the rehab facilities that tell us that, you know, they have 50% success rates. We can have some counseling. You're never sure if the person's committed a serious act of misconduct that it's not going to recur, and you're not going to be held responsible on a negligence standard or a second offense kind of standard. So I see oftentimes, and we counsel oftentimes, for more severe punishment than you might normally see in some of these areas if something serious has happened. And when the workforce gets tight like it is now, everybody's interested in last chance agreements and a final warning. Let's give them another chance. They're skilled, they're trained. Keep in mind, people like my wife sit on those juries, and they love to say, how could you let this happen? How could you let this happen? Knowing that for full well somebody else was going to be hurt or injured, even though you didn't know full well. So keep that in mind. I think we can end there. Adam, Sanjeev, and Jeff, pleasure seeing all of you, and nice to see everybody on the Zoom.
Thank you, Lou. And here's to hoping that Lou's wife is never on any of our juries. Couple final notes. Number one, there were a bunch of questions about whether the state has updated the minimum wage poster to reflect the new minimum wage. It has not yet. It's not on the state's website yet. The second question that we received quite a bit is whether or not the increases to the executive administrative salary thresholds went into effect. Although there have been no announcements regarding the increase, the proposed amendments were adopted without change, and they were published in the New York Register on December 28th. So those have gone into effect. I'll remind you, next week we have a year in review, which will highlight what has happened in 2022 of relevance to all of you. So thank you for being with us. Happy New Year, and we'll see you next week.